Everyone. Welcome to CWM. Today is Wednesday, December 21st. Okay, already we passed about 2/3 of this month, and we are moving forward to the end of the year. Today, we want to talk about broker commission protection. On the earth, do we have any broker commission protection? And because we are most agents, as public, are also aware that broker commission is not a salary based, is success fee based. So in other words, all the brokers, they have to put their own effort in advance, because at the end, at the closing, they will get the commission. So then the natural question is, how do we know at the end whether we're going to get the commission, whether the broker get the commission? And also in terms of a public, how do I pay a broker commission? So we want to review some contractual issues today. And the content would be the exception from New Jersey residential standard sales contract. So we will take a look at, in the contract, New Jersey residential sales contract, there are about 45 items, but today we want to review 3 items, especially they talking about commission protection. The item number 27, the title is Failure of a Buyer or a Seller to Close. As I said in the beginning, let's say the brokers, the real estate brokers, put their effort, but at the end, if buyer fails to close or seller fails to close, then what's going to happen? Then all the real estate agent put the effort, all effort becomes useless. So that is question. So obviously it cannot work that way. So we need to have some kind of protection. Whether we are protected on the contract, we want to take a look at that. So item number 27, it says, it's on the NJ standard residential sales contract. It says, if seller fails to close title to the property in accordance with this contract, buyer then may commence any legal or equitable actions to which buyer may be entitled. Well, we can understand that. If a seller fails to close title, it means buyer can sue seller. Okay. Whatever the actions to which buyer may be entitled. Okay, now, if buyer fails to close title in accordance with this contract, seller then may commence an action for damages it has suffered. And in such a case, the deposit monies paid on account of the purchase price shall be applied against such damages. So obviously, naturally and legally, the buyer, seller has more advantage. If a buyer fails to close title, let's say buyer just changed the mind, or buyer cannot bring the balance money. Okay. Then a seller has advantage because the seller's attorneys escrow account has the contract deposit. Well, in Northern New Jersey, we typically exercise up to 10% of the deposit money. So a seller can take the whatever damages occurred from the deposit money, the buyer's deposit money. So seller has advantage. Now, if buyer or seller breach this contract, if the buyers or sellers breach this contract, the breaching party will nevertheless be liable to brokers for the commissions in the amount set forth in this contract, as well as reasonable attorney's fees, cost, and such other damages as are determined by the court. So, if it turns out breaching the contract, either buyer or seller, okay, then the breaching party, whether that's going to be buyer or seller, the breaching party will have to pay the commission. That's what the contract says. What about reality? Well, this should also public knows, but buyers and sellers should know that legally, whoever breaches the contract has to pay the commission. If a buyer breaches the contract and cannot close, then indeed the buyer is liable to the brokers for the commissions. This is not what I am saying. This is what the legal agreement says, the contract. And buyer and seller, of course, signed this contract. And the attorneys went through the attorney review. So it's a binding 100% after attorney review is over. Okay, so that way, commission is protected. The next item, also item number 30, it continues. The title is Broker's Information and Commission. Okay, the commission, in accord with the previously executed listing agreement, of course, all the cases we have executed a listing agreement with a seller, typically, shall be, so commission shall be due and payable at the closing. We all know that. And payment by buyer of the purchase consideration for the property. And of course, the buyer brings the money. Okay, that's what they talk about. So seller hereby authorizes and instructs the whomever is the disbursing agent to pay full commission. Seller hereby authorizes and instructs whomever is the disbursing agent. So disbursing agent means typically title agent or sometimes buyer agent, the buyer attorney. So disbursing agent means the person who distributes the checks, whatever attorney fee, broker commission, and seller net proceeds, etc. So disbursing agent to pay the full commission as set forth below to the mentioned broker's form out of the proceeds of sale. Okay, so up until this moment, we understand that. So buyer authorizes and instructs to disbursing agent to pay full commission as set forth as we agreed, basically, from the proceeds of the sale. Okay. But this is important. Prior to the payment of any such funds to seller. So in terms of, let's say if there is an order, who gets the check first? Okay, let's assume theoretical situation, okay? The contract specifies the commission has to be paid first prior to the payment of such funds to seller. This is very interesting. Of course, at the closing table, is depending on the dispersing agent who gets the check first. It doesn't matter. More often, the seller will get the seller's money. We call net proceeds. So whatever the money, the buyer pays money minus all the expenses, and there is a net amount, correct? So typically we think, sure, seller will get the money first, or anyway as a highest priority. However, that's what we understand. But contract says commission first. Okay, the full commission, the dispersing agent to pay full commission as agreed from the proceeds of sale prior to the payment of such funds to seller. So that's kind of interesting, the contract issue. So that much commission is protected. A buyer consents to the dispersing agent making said disbursements. The commission shall be paid upon the purchase price set forth in section 2. That's in the contract at section 2, how much they paid, contract deposit how much, and the mortgage how much, and balance how much, etc. It shall include any amount allocated to, among other things, furniture and fixtures. And typically, the commission is based on sales price, but the contract says they all include any amount allocated to furniture and fixture and everything. So that's what the contract says. So it is protected well. I just want to point out that. The third one is item number 31st. This is a very interesting concept, the equitable lien. Most attorneys don't like this concept. I experienced. However, it's there. In the contract, it says, daily contract, you bring this contract everywhere, every day, right? And item number 31 is called equitable lien. Let's see what they're talking about. Under the New Jersey law, especially this item emphasized the New Jersey law, the brokers who brings the parties together in a real estate transaction are entitled to an equitable lien in the amount of their commission. This lien attaches to the property being sold from when the contract of sale is signed until the closing, and then to the funds due to seller at closing, and is not contingent upon the notice provided in this section. So whether the contract mentioned or not by the New Jersey law, the commission, it already specifies the commissions earned when brokers bring two parties together and make a deal. That moment, the commission is earned. But from that moment on, the broker's commission is just like equitable lien on the property. So you could imagine any other liens, okay? What happens if there are other liens? Primary, we have to take care of the mortgage lien, the first mortgage lien. And if there is any other liens, mechanical liens, or this owner owes someone and someone put the lien on the property, we have to clear that, okay? So that we can make the title marketable and sellable, transferable. And there's one more lien. It says, New Jersey law says, one more lien is what? Equitable lien, which is what? Broker's commission. So broker's commission is considered as equitable lien on the property. So naturally, legally, you have to take care of that lien in order to transfer the title to the other person. Correct? So that's what it says. That's the interpretation. And not what I am saying, but the contract says this lien attached to the property being sold from when the contract of sales is signed until the closing. So we looked at the New Jersey residential sales contract. So from now on, all the public actually should know about this as well. And also brokers, of course, all the agents should know what kind of protection built in the residential sales contract. What about commercial contract? Commercial is a little bit different word. Okay, commercial, I would say, not that strong protection in terms of a broker's commission. That is why all those, there's a lot of issues with the commission from the commercial properties. Well, first of all, also public should know some brokers, commercial brokers, they are not realtors. So they are not living by the code of ethics of NAR. In other words, sometimes a lot of commercial brokers, they are not member of NAR. So the protection, you have to take care of yourself. In other words, the brokerage has to take care of own protection in terms of a commercial transactions. Okay, I want to review in Korean. 오늘 지금 한 3가지를 검토해 봤는데요. 그러니까 우리가 커미션 잡이 이제 success based fee이기 때문에 일은 먼저 하게 되죠. 그래서 모든 일을 다 하고 실질적으로 우리가 커미션을 받는 것은 클로징 때 받는다. 그러면 내가 어떻게 커미션을 받을 줄 알고 이 일들을 다 어려운 일들을 해내느냐. 그래서 계약서 자체에 보면 이 프로텍션이 되어 있다. 그러면 어떤 프로텍션을 도대체 가지고 있느냐? 뭐 실질적으로는 조금 차이가 있을 수 있어도 그러나 일단 계약상에는 이런 프로텍션이 제공되어 있다. 첫 번째 아이템 넘버 27 그 NJ Residential Standard Sales Contract에 보면 아이템 넘버 27에 뭐가 들어가 있느냐 하면 failure of buyer or seller to close. 만약에 셀러나 바이어가 클로즈를 못하게 되면 그러면 이제 물론 서로에게 물어줘야 되겠죠. 셀러가 클로징을 어떤 이유든 못하면 계약상에 클로징하게 돼 있는데 그럼 바이어가 데미지를 이제 요청할 수 있겠죠. 또 바이어가 페일하면 마찬가지 셀러가 요청할 수 있는데 셀러가 유리한 게 셀러는 바이어의 디파짓 머니를 가지고 있다. 그런데 재밌는 것은 어느 쪽이건 브리치 한쪽, 그러니까 계약을 위반한 쪽이 브로커 커미션을 페이하게끔 돼 있다. 그 조항이 들어가 있는 거예요. 그러니까 보통 우리가 typically 마켓 때문에 셀러가 usually 커미션을 지불한다 이렇게 돼 있는 거죠. 그런데 만약에 바이어가 브리치를 해서 클로징을 못했다. 계약 위반을 해서 그런 경우는 이 계약서에 프로텍션 돼 있기로는 바이어가 커미션을 지불해야 된다라고 돼 있는 거죠. Breaching party will nevertheless be liable to the brokers. 그게 이제 우리 퍼블릭이 알아야 될 일이고 또 우리 에이전트들이 프로텍션을 가지고 있다는 것을 알아야 되겠죠. 그 다음 또 항목이 아이템 넘버 30에 또 있어요. Brokers Information and Commission이라고 해서 그러니까 전체적으로 Residential Sales Contract에는 한 3군데 정도의 커미션 프로텍션이 들어가 있다. 이거는 뭐냐 하면은 물론 클로징 테이블에서 다 이제 체크를 나눠 갔죠. 그 디스퍼싱 에이전트라고 그러죠. 뭐 쉽게 얘기하면 체크를 나눠주는 사람이다. 이런 얘기죠. 물론 바이어가 돈을 다 가지고 오겠죠. 그럼 그 돈에서 셀러는 authorize를 하죠. 거기서 페이를 다 하는 걸로 authorize 하는데 그 중에 당연히 풀 커미션이 있죠. 약속된 바대로 풀 커미션을 authorize 하는 거예요. 셀러가 dispersing agent한테. 그런데 더 굉장히 재미있는 것은 그 셀러의 돈을 지불하기보다 먼저 prior to the payment of seller, commission has to be paid. 그러니까 무슨 뭐 그 한 자리에서 무슨 순서가 있겠습니까만은 그러나 이 문장상으로 볼 때에 셀러한테 우리가 net proceeds라고 그러죠. 다 경비 떼고 나머지 셀러가 이제 딱 가져갈 돈 그걸 페이하기 전에 커미션 풀 커미션이 먼저 지불해야 된다. 이런 조항이 있다고 하는 거죠. 그러니까 가끔 문제가 되죠. 무슨 커미션 문제가 생기면 브로커의 컴퍼니의 브로커는 사실상 이 조항 때문에 강하게 클로징을 스탑시킬 수도 있어요. 왜? 이 조항이 있기 때문에. 그래서 컨티뉴 하게 되면 그리고 이제 어떤 조항에 의해서 그러니까 계산하는 것도 토탈 세일즈 프라이스는 당연하고 뭐 여기서는 무슨 바이어가 사게 돼 있는 포니처나 픽처 같은 것도 전체 어마운트에 포함시켜서 커미션이 페이된다. 이렇게 지금 돼 있는 거죠. 자, 그것도 일단은 퍼블릭도 그렇고 바이언셀러도 그렇고 에이전트들도 알아야 되겠다. 그 다음에 마지막 이것이 굉장히 재밌는 컨셉인데요. 이 컨셉은 경험상 보니까 변호사님들은 별로 안 좋아하세요. 왜냐하면 또 하나의 골치를 해결해야 되는 그런 그 식으로 생각을 하기 때문에 왜 그러냐면 뉴저지 러에 이거는 그 계약이 아니고요. 뉴저지 러예요. 러에 어떻게 되냐면은 커미션 자체가 우리가 사람들을 바이어셀러를 만나게 해서 딜을 만들었잖아요. 그때부터 커미션이 on 됐잖아요. on 된 다음부터 그러면 클로징 할 때까지는 그럼 도대체 이 돈이 어떻게 되어 있는 거냐? 그래서 entitled to equitable lien이라고 하는 단어가 있어요. equitable lien. 그 on이 됐잖아요, 커미션이. 그럼 실질적으로 그때부터 이 프로퍼티에다가 lien을 걸어놓은 거랑 똑같다고 그래요. equitable lien이라고 그래요. 그래서 this lien, the contract says, is this lien attached to the property being sold from when the contract of sale is signed until the closing. 그러니까 우리가 딜을 만든 그 순간서부터 클로징 때까지 이 집에는 커미션이 equitable lien으로 붙어 있어서 클로징 때 페이하면 그것이 이제 클리어되는 거와 같은 작용을 한다 하는 거죠. 자, 그래서 이렇게 프로텍션이 되어 있는 거를 여러분들이 아시고 일을 할 때 자신감을 가지고 일을 하시고 또 무슨 문제가 생겼을 때는 당연히 즉시 브로커하고 통화를 하지만 이러한 백그라운드가 있다. 리걸한 백그라운드 이런 걸 있다는 생각을 가지고 움직이는 거하고 이런 걸 전혀 본 적이 없는데 커미션을 받을 수 있나 쭈삣쭈삣해서 low confidence를 가지고 일하면은 안 된다. 그러니까 legally protection이 완전히 돼 있기 때문에 여러분들이 자신 있게 일을 할 수가 있어야 된다. Okay, so today we review the broker commission protection in terms of New Jersey residential standard sales contract. I hope this helps a lot to understand the commission protection and also the seller-buyer obligation to the broker commission. Okay, thank you for joining. See you all next week.